August 9, 2008, a forum organized by the Malaysian Bar Council titled Conversion to Islam, Article 1211A of the Federal Constitution, Subashini and Shamala Revisited, was cut short by a group of angry Muslim NGOs. They gathered at the Bar Council building and ended a seemingly innocuous forum to discuss the plight of spouses facing divorce and annulment of marriage by the conversion of one party into Islam.
Sesungguhnya kita tidak pernah untuk menggugat kestabilan agama orang lain. Maka kita harap juga pihak-pihak lain jangan cuba untuk menggugat agama Islam dekat kita ini. Tak ada tapi tak tahu undang-undang. Bincang kepala otak bincang.
So what brought about so much anger?
Pertamanya kita membantah keras forum ini kerana forum ini mempertikaikan kedudukan mahkamah syariah yang telah diperuntukkan dengan jelas di dalam perlembagaan di bawah artikel 1211A, dan keputusan Mahkamah Persekutuan sendiri di dalam kes Azmi Rijal ini telah menyamatarafkan mahkamah syariah dengan mahkamah sivil dari segi bidang kuasa masing-masing. Kecubaan Majlis Peguam hari ini untuk mengupas kes Subashini dan Shamala menunjukkan mereka tidak menghormati keputusan Mahkamah Persekutuan dan tidak menghormati langsung peruntukan perlembagaan persekutuan. Dan yang lebih parahnya, ianya telah mengguris perasaan umat Islam.
If you look at it, what is Article 121? Article 121 basically states what is the jurisdiction of the civil courts and what is the jurisdiction of the Sharia courts. And it says that if a matter is in the jurisdiction of the Sharia court, then the civil court does not have jurisdiction. That's all it is. And for many years there was no problem with that. Yeah. So the next question is, what is the Sharia court's jurisdiction? That is also determined by the Constitution in Schedule 9. There's a list which says that the Sharia court deals with these matters. So as long as the issue is within that list, then the civil courts have no jurisdiction, and nobody's disputing that. I don't think the forum was disputing that.
1A says that the High Court shall have no jurisdiction in any matter within the jurisdiction of the Sharia court. So the intention at that time was to just make sure that Muslims who had gone to the Sharia court and were not happy with the Sharia court decision couldn't then hop over the fence, as it were, come to the civil court and take a second bite at the cherry. Now that was the reason why 1A was put in.
One case that was to be discussed was Subashini versus Saravanan, and the issue surrounding this case needs to be understood before the bigger issue of Article 1211A can be appreciated.
At that material time when Subashini filed her petition, she filed an application to ask the court to restrain, the civil court that is, to restrain Saravanan from continuing with the Sharia applications in the Sharia court. So that was the crux of the matter.
If you look at the federal court's decision in the Subashini case, it's saying that she has, the civil courts has jurisdiction, the Sharia court also has jurisdiction. The federal court has said both courts have jurisdiction. This is a completely unsatisfactory decision, all right, and it has left it open as to who is going to decide the case. Now, what if she goes to the civil courts, he goes to the Sharia court, and they come up with different decisions? How are you going to solve that? These are the kinds of issues which are unresolved, and these are the kind of issues which the forum, I believe, was trying to solve. Yeah?
Kita menentang keras orang yang diadakan pagi ini kerana menghina dan mencabar kita. Saya telah berunding dengan Ketua Polis Daerah Dambangi, Tuan Zulkifli, dan saya telah beri tempoh sehingga 9.30. Kita minta OTPD supaya naik dan hentikan segera forum
conundrum here is that in cases like Subashini Saravanan, there is an overlap of the court system, something that Article 1211A had intended to avoid.
So our argument is that the facts of this case and the nature of the case actually is within Sharia court, even though it involves or it actually affects a non-Muslim, because the law, the principles applicable are all governed by Sharia principles, not civil law. That was our argument. Of course, Subashini's counsels and solicitors were of a different view. That no, even though her husband converted, Shafi converted to Islam, and he may have a right to ask the authorities to allow him to use Islamic law on himself, but because his earlier marriage is with a Hindu wife who remains a Hindu, so the jurisdiction is with the civil court. That is where 1211A was the crux of the matter in that case, to a certain extent.
Well, see, this is the other thing. Sharia courts only have jurisdiction where everyone involved in the dispute is a person professing the religion of Islam. So Muslims, you know, someone who says he's a Muslim. So if one person is not, then actually the Sharia court has no jurisdiction. And this again has been reaffirmed in Subashini's decision, Latif Ahmad Zain and Haji Kaha. So actually, in my view, all those spouses, when they convert to Islam, they actually had no right going to the Sharia court. Of course, because what the Sharia court does is it deals with disputes where all parties are Muslim. Unfortunately, that's my view. The federal court in Subashini's case, what it decided, the majority 2 judges decided, is that Sharia court only has jurisdiction where everyone is a Muslim, but if you are a Muslim in that situation that you said, a convert from a non-Muslim marriage, you can still go to the Sharia court, they said. But then they went on to say, whatever you get, the order you get from the Sharia court has no legal effect in the civil high court. What that means is still a little bit up in the air, and we'll have to see exactly what effect that is. But in my view, actually, that convert to Islam should go to the civil courts. The argument has always been the provision in the Law Reform Marriage and Divorce Act only allows the non-converting spouse to ask for divorce. Meaning husband and wife, husband converts, only the wife can ask for divorce. But even in some situations, there have been cases where when the husband goes to ask for divorce, even though he's a Muslim, the courts have allowed it. So it is still an option available to them. But instead, many choose to go to the Sharia court, and obviously the non-Muslim spouse cannot go to the Sharia court because, you know, it applies Islamic law, which doesn't apply to her.
President of the Sharia Lawyers Association, Zainul Rijal, explains the conflict between civil and Sharia laws in this country.
The problem here is not the family of the convert or the non-converting parties. The problem here is the law. The law is the main problem, because Section 51 of the Law Reform Marriage and Divorce Act gives the rights to the non-converting party to petition for the divorce for the non-Muslim in the civil court. Whereas for Section 46(2) of the Islamic Family Law gives the rights to the converting party to petition in Sharia court. So there are two ways of doing one thing. This is the problem.
So Section 51 of the Law Reform Marriage and Divorce Act gives the non-converting party the right to petition for divorce. The converting party, on the other hand, would not want to go to the civil courts for divorce and will do so in the Sharia court. But which court shall recognize which decision? This is a question that the courts have seemingly found difficult to decide on.